3, 2, 1, ready, start. The rules framed under the Act also do not confer any such power, and in absence of any source of power, the tribunal, being an authority of limited jurisdiction, cannot exercise such powers to order an eviction. Submissions on behalf of the petitioners, Sri Anurag Narayan Srivastava, Learned Counsel for the petitioners, submitted that as the title of the Act of 2007 suggests, the Act was primarily promulgated not only for the maintenance but also for the welfare of the parents and senior citizens, and in order to fulfill the objects of the Act as well as to create a robust system for providing maintenance and welfare for the parents and senior citizens, the authorities under the Act of 2007 are conferred with ample powers to pass such orders as may be necessary and required to protect the right of residence of the parents and senior citizens and to enable them to live with dignity and peace. The authorities, in order to achieve this laudable objects of the Act of 2007, are empowered to pass appropriate orders, including an order of eviction of children or relatives, as the case may be, if the same is inevitable for making the relief granted to such senior citizen parent more relevant and meaningful. Full stop. Para. It was further submitted that the scheme of the Act of 2007 is such that the forum of appeal is provided only for the senior citizen or the parent, and it does not give a right to the children or the respondent in the complaint before the maintenance tribunal to avail such a forum of appeal. However, the appellate tribunal, while exercising the powers of appeal, can pass appropriate orders, including an order of eviction, to ensure that the maintenance as defined in the Act of 2007 is expensive and it inter alia includes a right of residence. Hence, a restrictive meaning should not be ascribed, and in order to ensure that the senior citizen / parent who has a right of residence accruing under the Act, can reside with dignity, then it necessarily requires that the appellate tribunal is clothed with the power to remove any such obstruction which may create an impediment for a senior citizen / parent to live in a dignified, peaceful and respectable manner. It was further urged that Rule 21 as framed under the Uttar Pradesh Maintenance and Welfare of Parents and Senior Citizens Rules, 2014, hereinafter referred to as the Rules of 2014, confers powers on the district magistrate, who is the appellate authority can pass such orders as may be necessary, including the power to pass an order of eviction. Stop. The learned counsel for the petitioners further submitted that the apex court in S. Vanitha versus Deputy Commissioner, Bengaluru 2021 in bracket 15 bracket close SCC 730, while considering the interplay between the provisions of protection of women from Domestic Violence Act 2005 bracket hereinafter referred to as the Act of 2005 bracket close and considering the Act of 2007, held that the two acts and their provisions have to be harmoniously construed, and in certain circumstances, the power of eviction, which lies in the hands of the tribunal, can be exercised by it. Stop. Para. Learned counsel for the petitioner further submitted that where the attitude, behavior and actions of children relatives are not conducive vis-a-vis their parents senior citizens, then in such circumstances, the senior citizen parent may experience trauma and face a difficult situation, and due to pressure and emotional dependence, it may be hard for the parent senior citizens to exclude or oust such children relative while silently braving the emotional and physical trauma. Stop. In such circumstances, the Act of 2007 comes to the aid of such traumatized neglected parent senior citizen, and in proceedings under the Act of 2007, if circumstances so warrant, then in the given circumstances, the authorities in deserving cases can pass appropriate orders, including an order of eviction for the benefit and welfare of the parent senior citizen. Stop. Para. It was further submitted that where the property in question belongs to the senior citizen, and in cases where the senior citizen parent is mistreated by their children relatives, then it cannot be said that they lose their right to seek eviction of their children relatives, as the status of such children relatives is nothing more than that of a licensee, and the parent senior citizen in capacity of the owner licensor can seek the removal eviction of the children who, really speaking, do not have any independent right to retain or remain in the said property against the wish of the parent the senior citizen. Stop. The learned counsel for the petitioners also submitted that in the division bench decision of Swaraj Varun in bracket supra bracket close, comma, the court did not consider the scope of a residence order while the word maintenance as defined in the Act includes the right of residence, and such an order of residence can be passed by the maintenance tribunal.